So it's my pleasure right now to introduce Dr. Paul Zaleza, who's the Vice President for Academic Affairs here, brand new, just started with us, who's also a Professor of History with us. He is going to be introducing our keynote speaker, but it's my great pleasure, Dr. Zaleza.
Good afternoon. It's my pleasure to introduce our keynote speaker, but I can't resist thanking various people for this absolutely wonderful conference, Symposium. First of all, Dean Jennifer Brown, who has been a wonderful colleague that I've worked with in the last 3 months that I've been here, and of course the organizers, including Professor Kari Kass, who's been moderating the conversations, and certainly I've enjoyed the various presentations and the commentaries that have been made. I didn't come here just because I'm supposed to say a few words as the Vice President, but also because the kinds of issues that are being discussed today speak to my own scholarly interests. As some of you might know, I've done some work on human rights. I'm very much interested in issues of war and conflict and post-conflict reconstruction. In fact, I edited a couple of books on post-conflict reconstruction in various parts of Africa. And as a historian, I was absolutely fascinated by the discussion about memory and how collective memories are constructed, debated, contested, and so on and so forth. That's what we do as historians. So for me, it was quite refreshing to hear that other people in other areas, including the legal field, are very much interested in memory. So thank you for the wonderful presentations. It's now my pleasure to introduce our speaker, Ruti Teitel. Ruti Teitel is an international recognized authority on international law, international human rights, transitional justice, and comparative constitutional law. Ruti Teitel is the Ernst C. Stiefel Professor of Comparative Law at New York Law School. She's a visiting fellow at the London School of Economics. It happens to be my old school, and affiliated visiting professor at Hebrew University of Jerusalem. Her path-breaking book, Transitional Justice, published in 2000, examines the 20th century transitions to democracy in many countries. Born in Argentina, Professor Teitel's interest in the topic grew out of the dilemmas confronting the society in the transition out of junta rule. Her book explores the recurring question of how new regimes should respond to past repression, contending that the law can play a profound role in periods of radical change in advancing a new sense of legitimacy. Her most recent book, Humanity's Law, explores a paradigm shift in international affairs. Her extensive body of scholarly writing on comparative law, human rights, and constitutionalism is published in many law reviews, including the Cornell International Law Journal and the Harvard Law Review. She has also contributed dozens of book chapters to published volumes relating to law and politics. She also writes on human rights issues for a broader audience, having published in the New York Times, Legal Affairs, FindLaw.com, and Project Syndicate. She serves on the board of editors of Oxford's International Journal of Transitional Justice, as well as the editorial advisory board of the Interdisciplinary Journal of Human Rights Law. A cum laude graduate of Georgetown University, Professor Teitel received her JD from Cornell Law School and has been a senior fellow at the Orville H. Shell Jr. Center for International Human Rights at Yale Law School. She has taught at Yale, Fordham, and Tel Aviv law schools, as well as Columbia University's Politics Department and its School of International and Public Affairs. Last year, she was a Strauss Fellow in Residence at New York University Law School's Strauss Institute for the Advanced Study of Law and Justice. She is the founding co-chair of the American Society of International Law, interest group on transitional justice and rule of law, a life member of the Council on Foreign Relations, and a member of the International Law Association Human Rights Committee, London and the US. She's on the steering committee of the University of Leiden, Grotius Center for International Legal Studies, Post-Conflict Justice, and Local Ownership Research Project. It's really an honor for you to be with us this afternoon. Thank you.
Well, thank you very much for that wonderful introduction. And I want to thank the organizers, the student organizers, as well as the Center for Dispute Resolution and the university as a whole. It strikes me from what I've heard since I came in. I'm sorry I wasn't here at the very beginning. I had a commitment in New York last night. It seems like a very stimulating day, and that you're really addressing the key issues in the development of the field. So in my time in the keynote, and I want to leave time for questions, I just want to draw your attention to the ways that transitional justice appears to have changed in the last couple of decades since I've been following the field. So my remarks are going to address both the practice and study of transitional justice since my book in 2000. And what one can see from contemporary conflicts in the Middle East, as well as postponed transitional justice in Latin America, Cambodia, and elsewhere, is certainly that there is a remarkable amount of experience and experimentation by now in transitional justice. I'm going to talk about a paradigm shift. Certainly in the recent political awakenings in the Middle East, there's been a call for accountability that was front and center in the demonstrations in Tahrir Square. It was also seen in the demands by the international community and its court in the midst of the Libyan conflict. Indeed, what's clear from the latest political and legal changes is that transitional justice is no longer a byproduct or an afterthought, but rather often the driver of political change. Where transitions are fraught and democratization a distant goal, it's the demand for transitional justice that has become both means and ends, and we can see changing expectations of law and other demands at this time. And of course, this also produces tensions between the demands of transitional justice and the political context. So one can see the demand for justice and accountability underway on many levels, beyond war itself, often ex ante, beyond the transitional state, ranging across public and private sectors to the galvanizing of civil society, with implications for the rethinking of the meaning of transitional justice, where it is accountability conceived in rule of law terms that appears to offer a distinctive source of legitimacy. Yet I'm going to suggest this is a relative legitimacy which is always informed by a transformative politics of often limited and unstable transitions. Now, to appreciate the road traveled, let's reflect back to when the modern day notion of transitional justice was crystallized. At the end of the 20th century, transitional justice emerged and came to be identified with a vital debate over how to reckon with the abuses of predecessor state regimes, particularly in light of the aims of democratization and state building associated with the political transitions of that era. At the time, and this is really distant history for most of you, I was commissioned to write an advisory memorandum in the very early 90s for the New York-based Council on Foreign Relations, which was aiming at clarifying a debate and making recommendations about justice at the time of the Latin American transitions, particularly in the Southern Cone. In the policy memorandum, I advocated a broader view of transitional rule of law than that originally posed at the CFR debate, which was cast in terms of punishment or impunity, and whether it was possible for countries like Argentina, Uruguay, and Chile to have new democracies if they didn't hold trials. Indeed, given the nature of the transitional context, I argued that wherever the criminal justice response was politically unwise or simply unpractical, where there were holdover judiciary or it would involve retroactive legislation, that there were other ways to respond to the predecessor regime's wrongdoing and repressive rule, and moreover, that such alternatives could advance the rule of law. The quote, at the time, the extraordinary transitional form of punishment gave way to, quote, the limited criminal sanction, which was directed less at penalizing perpetrators and more at advancing the political transformation's normative shift. What I realized after that memorandum is that, and it was probably one of the hardest 10-page, I think they had a 10-page rule, I might have gone into 11 pages, but think tanks, there's not a lot of time. And I realized after that memo and the Berlin Wall had collapsed and there were changes going on in Eastern Europe, that this was hardly a problem only of the Southern Cone in Latin America. And it led to my working on my book and a grant proposal with the United States Institute of Peace to do research and in Eastern Europe and in Latin America. And later in 2000, I published my book. Well, the idea in smushing together these two words, transition and justice, my aim was to account for the self-conscious contingent construction of a distinctive conception of justice associated with periods of radical political change after past oppressive rule. It would become clear that the path chosen would fall short of ideal conceptions of justice. And this is why the term struck me as important. Rather, transitional justice was an exercise in law and politics, where line drawing was endemic, informed by felt necessities, as well as a country's long-standing traditions relating to the rule of law. And here the idea was that it was both extraordinary and constructivist, and that it would be contextual and partial. With the collapse of communism, it became evident that this provisional feature constituted the preeminent characteristic of transitional justice. The structure of legal responses was shaped by the circumstances and parameters and often limits of the associated political conditions. Further, one could also see that normative political change itself was contingent on the degree of commitment, political commitment. So several conclusions followed, and that is that transitional justice would not reflect the ideals of rule of law. Moreover, in such hyper-political moments, these could often be seen as teaching tools for lawyers and the legal system. The law would operate differently. It was often a question of degree. It would be nearly impossible to meet all of the traditional values associated with the rule of law, such as general applicability of the law, procedural due process, as well as more substantive ideas of fairness and legitimacy. After the post-Cold War phase, reflecting, one can see a proliferation of transitional justice, there are now 2 decades of experimentation and change. And so I argue in a book that's forthcoming that we've turned to a new global phase of transitional justice. And it builds on an article I wrote for the International Journal of Transitional Justice, where there's a contemporary paradigm that's associated with a distinctive context of global politics. And I want to juxtapose it to these early debates so that we can see in relief some of the changes associated with this new paradigm. And some of these points and tensions, synergies and tensions have already been alluded to in the earlier comments and the earlier panel. So the early debates, as mentioned, involved a somewhat artificial and zero-sum framework that centered on a set of quote-unquote foundational dilemmas, such as punishment versus impunity, truth versus justice, peace versus justice, and I know we're going to hear more about peace versus justice later. In these debates, the role of the state loomed large, and I would say that you could think of these as state-centric transitional justice, strong state transitional justice, often patterned on Nuremberg and the Germany example, with the problem of justice revolving almost exclusively around state actors and related institutions, such as security apparatus and police. In transitional justice early days, the central concern was framed in terms of how a successor regime ought to respond to abuses perpetrated by the state and against its own citizens. And you can see from the writing at the time, Arya Nair, who was head of Human Rights Watch, what is to be done about the guilty. It was really emphasis on the perpetrators. I aim to reframe this question in that CFR debate, which is how should a society come to terms with its violent, repressive past? And one can see that, that at the time there was this extraordinary focus on the state, and the analogy seemed to be a constitutional approach, where the emphasis was on the problem of the strong state and the response conceptualized in terms of constraining bad state actors, as well as recognizing individual rights and responsibilities. Indeed, transitional justice would come to be coincident with changes in Latin America, Eastern Europe, and South Africa, commitments to new constitutionalism. And these were often associated with analogous punitive and administrative responses and changes in the civil sector. Now, more than 2 decades on, I just would, and this is really in the spirit of exchange because this is an ongoing project, I think, for all of us, how have the central questions changed? I argue that the changes amount to a global paradigm of transitional justice. For the very problem of justice is being reconceptualized through a global politics of accountability, often in the context of weak rather than strong states, and beyond the primary focus on abuses of state power, with evident implications for the transformative challenge. Indeed, accountability for past wrongs is being demanded in situations often where there is no clear or consolidated political transition. In fact, sometimes I've been asked about transitional justice in Syria and in between the 2 revolutions in Egypt. I said there's no transition, no transition, no justice, and then one can have a conversation, okay? Indeed, there is evidence of its normalization to intra-conflict and even ex-ante conflict. If before the centrality of the transitional problem was the predecessor regime and its excesses, constitutional-style delimitation of state power, now the challenge of contemporary transformation is that it engages directly non-state actors at all levels and their behavior and entails changing social norms, building civil society, and a demand for adequate institutions and capacity building. In an increasing number of weak and failed states, from Eastern Europe to the Middle East to Africa, the overriding goal is the assurance of a modicum of security and rule of law that, even apparently without other political consensus, is supposed to be a basis for contemporary legitimacy. Let me just throw out 3 dimensions to transitional justice globalized. One is that this expansion of the aegis of transitional justice, or if you will, the normalization or standardization of transitional justice. And this seems a real departure from the 1980s. In the 1980s, certainly the way I thought about it, and many scholars at the time, as well as practitioners, was that this was justice seeking in periods of exception, that these were extraordinary periods. Now we see transitional justice more often than not disassociated from the politics of transition and reflective of a new normalization. And there are several models one might think of this normalization, and I'm going to elaborate on them in future work, but I'll just mention them here, and maybe we'll have time to talk about it. One is a bureaucratic model, which could be seen as technocratic best practices, and the other is kind of formal international law model. In any event, the globality is evidenced along a matrix of the passage of time, and this was mentioned earlier. What is the relevant period for transitional justice? To what extent does it extend beyond the immediate time of regime transition? What was initially conceived as transitional justice has become normalized as accountability for certain kinds of very serious systemic wrongs, and we see this in a variety of settings, certainly with the creation of the International Criminal Court, which applies not just in periods of war, but it really can be seen to monitor other instances, such as the recent Kenyan elections, with the creation by the UN Security Council of the Intra-Conflict Tribunal in the Balkans. Again, this was pre-transition. It was specifically not victor's justice, and it was intended, by being set up before the end of the war, was set up as being the antithesis of victor's justice. And you can ask yourself what that would be. And more recently, with Libya and the Security Council referral, there is this, if you will, normalization of these responses, where there's moving up of the transition across war-peace lines and an increase in the attempts to use law to impose ex-ante settlements via transitional justice mechanisms. Now, there are lots of controversies we can see as well about the ongoing viability of local responses, as well as the potential role of law, and these have been alluded to already, justice versus peace, international versus local, and these overlap up in interesting ways, and you know, they've been already mentioned. Now, with the normalization of the field, well, now we talk about a field. It was seen as an exceptional set of practices and exceptional theorization. Now there is talk, and I think that, you know, the use of this term, that transitional justice has developed into a field of scholarship that crosses disciplines. There's a struggle over the control of the field, and this is what was interesting to me about the university-wide conference. It's often intense. There are those who would maintain that the new focus on practice and interdisciplinarity is a move away from legal control of these issues and the original focus on punishment or impunity. While one might differ upon what the original focus is, there's no question that there is now concession to a much broader range of mechanisms, goals, and inquiries, and this is what makes up this quote-unquote field. Now, what to make of these interdisciplinary developments? What is its relationship to the original aims of transition that have been alluded to, the politics with a capital P, to security and development. We can certainly see that major actors, non-state actors such as the United Nations, have made increasing reference to transitional justice in both Security Council and the General Assembly, linking up transitional justice to rule of law, to peacemaking, and a variety of other broader goals. There are practitioners that advocate a holistic or ecological approach. Others invoke best practices, but the question to my mind is best according to what measure? To what extent can such general practice-based approaches that aim for standardization, to what extent can they be sensitive to politics and context? They certainly fall out of one discipline, law or politics, but then the question becomes how to conceptualize the field. From the vantage point of the bureaucratic model, justice becomes just one piece in the toolbox of practices, whereas from the other side, the formalist legal side, we see transitional justice as very tightly connected to a set of formal obligations. Now, let me just say a little bit more about these two models. The landscape today, as mentioned, includes far more than the state. So not only is it normalized in terms of time, but also the landscape includes a great variety of stakeholders, not just the direct participants in the transition. And this is very different. If one thinks back to Argentina and the trial, there was a big trial. The trials process was stopped and has now been revived. If any of you have been to Argentina recently, 3 decades after the facts, there are trials of the leading human rights abusers. But one of the important central claims made in that first trial by the prosecutor was, this is not Nuremberg. We are trying ourselves. This is something where we are the stakeholders. Now today there are many stakeholders there, and that's the reference to the global. There are local actors, there are regional actors, there are international actors and institutions, as well as this amorphous global civil society. And we see victims groups, for example, in Argentina that have gone to Spain, and Spanish victims that have now raised claims in Argentina. A world that is increasingly connected and interdependent, but remains not politically integrated. And so this tendency to superimpose international law as the normativity. And we see, this ascendancy as well of more judiciary, the International Criminal Court, but also the use of domestic jurisdiction, the normativity that goes beyond just The Hague, the use of language in those terms, crimes against humanity, et cetera, appearing and shaping the discourse locally. What might this direction tell us about where this is going? We certainly can see a greater sense of management of transitional justice as an issue of global governance. There is cross-border transnational engagement, and certainly we saw this with respect to Libya, but also places like Cambodia, Sierra Leone, and Iraq. There were debates about how much internationalism should there be, how much international intervention versus how much local. One solution, quote unquote, has been to adopt hybrid mechanisms such as East Timor and Sierra Leone, but then the question often becomes in the hybridity between the international and the local, where is there accountability? Overall, as I've mentioned, there are these two sides of this global paradigm. One is the bureaucratic, the emphasis on the bureaucratic, and the other is international law. Now, let me just say something more about each of these, and I think they raise a number of questions and tensions, and so it would be great to have a possibility to talk further in the Q&A. On the bureaucratic side, and I see this certainly at the UN, there are regular reports about what are the pillars of transitional justice, and a reflection that there are 4 pillars, including some that have been mentioned today, such as a right to truth, a bureaucratic approach that tends to theorize across transitions and across regions, and seems to be guided by a scientific analogy, and you see it as, you know, a prescription, that there's a prescription to leading states, states undergoing transition. An example today would be Tunisia, where the UN is running a program on transitional justice. The International Center for Transitional Justice, which is a leading NGO in the field, also conceives of transitional justice according to a very different definition than the one I proposed earlier in the remarks. They see transitional justice as the set of responses. So it's the array of practices, and that's why I say that this has become a technocratic, this is the technocratic model. It's a set of answers. And then we could ask ourselves, what is the problem, right? It's a set of responses where there are lessons that can be learned worldwide, from Truth Commission over here to another one over there, and that's really one side of this picture. What has the effect been of having some of these, this bureaucratic development? Certainly, we see in Tunisia a division between those in the political process, between perpetrator and victim. That has become a central defining line in this process. It has delayed constitution building there. Can one build a new society and a new citizenry based on these categories of perpetrator and victim? There are others who have also commented on bureaucratic decision-making. We can see it in the work of David Kennedy and his critical work on humanitarian aid and international intervention. Then there are scholars such as Fletcher and Weinstein that look to a number of factors to see where intervention might be most appropriate. If we turn to the international law model, you know, this is the other dimension we can see, and, you know, international law has been in the picture since the late 80s. It was an alternative normativity in Eastern Europe when there were issues of retroactivity, for example, in Hungary, where they wanted to prosecute those who had been involved in the violent repression of the 1950s. It was used in Czechoslovakia before the crimes that were committed at the time of the Prague demonstrations. And you know, solving this problem, international law seemed to be a great, you know, almost a gimmick, because it gave some kind of normative continuity in a period of transition which is, you know, characterized by value switch between regimes. And so international law has been in the picture from the beginning. But what we see now is really its entrenchment through the various charters, the charters for the ad hoc tribunals and the Rome Statute, and these have given rise to a certain conceptualization of what are the most serious offenses. They may also give us a principle for figuring out how to deal with the global paradigm. The International Criminal Court, as mentioned, is a permanent court, so it's at least permanent for its signatories, and it has to figure out its relationship to other standing bodies that worry about crime and security. And so there's a norm that the criminal court, and a principle of jurisdiction, this principle of complementarity, which attempts to guide the relationship of the domestic and the international on a continuous basis. And there we might see some glimmerings of light for how to think about this, the problem of a field that has expanded in the ways that I've described, and the global context of domestic, political, regional, and international. And as you may know, the principle of complementarity essentially looks to the context in the domestic jurisdiction to see whether there should be international intervention. And where there is political will and capacity, then the international institution should step back and put it conversely. It's I would argue, you know, and to put it more strongly than is put in the Rome Statute, it should be in instances of political failure that international intervention is at its most justified. Now, you know, that's a position, that's a way to think about the globalization of transitional justice. Nevertheless, there's a whole school now of if you will, international formalism, legal formalism, with a variety of different scholars, both from political science and law, who are emphasizing the cascade of human rights trials as contributing to the rule of law, and others who essentially argue in the human rights community that there's an obligation to punish. Now, you know, I just want to throw out some recent confrontations that bring together these two models and really raise questions for us about the direction of the field. To my mind, international law is not one value, and it's not an absolute. International law needs to be interpreted. And we see of late a number of different instances of conflict which reflect the fact that both of these models, both the bureaucratic standardized practices model as well as the formalist international law approach, both of them are inadequate to really lead the field because they're conceptualized as disconnected from the transition's substantive political commitments and values. So we might take up some recent contestation and think about what some potential guiding factors might be. What are some recent instances of contestation reflecting this global paradigm and these, in particular, the failures of these two dimensions that I've mentioned, this disconnect from politics. So, you know, I think one that's been glaring and is the most contemporary is the relationship of the International Criminal Court to the current administration in Kenya. And we've seen over the last year an indictment, an election, an attempt, you know, a granting of postponement, then a reversal, and now it appears to be a postponement again, with the AU threatening to pull out of the court as a bloc. If that were to happen, the African Union was the leading region, along with Europe, to support the International Criminal Court, and arguably the court would be eviscerated if the AU pulled out. So it's a really critical moment in the life of this institution. And there have been ongoing debates in New York and elsewhere, and in particular the International Peace Institute, those of you who are interested, sponsored something of a debate on this issue 2 weeks ago. So that was an instance where the court has to reflect on its context, you know, what principles might guide its prosecutions. You know, it says that it's mandated and under an international legal duty, and that there, you know, the prosecutor has until recently maintained that there is very little discretion in the prosecution. And so you can see this kind of formalist, international formalism appearing there. Another example, also the ICC, is Libya. And we see an exchange, a number of, you know, back and forth on whether trials should be occurring in Libya or in The Hague, and very little scholarship and very little studied reflections that are transparent on the issue of what is complementarity, reflections on when the court should be involved. And one might think, for example, that complementarity should mean some understanding of what a fair trial is. And up till now, this has not been articulated as one of the dimensions of complementarity. Some of you may or may not know that the Gaddafi regime was referred to the International Criminal Court pretty much at the same time of the Libyan intervention, and now there are two different rulings by that court about whether a trial can occur in Libya. One for al-Sanusi, who was one of the henchmen there, and another for the son, Saif Gaddafi. Whatever you might think about these particular instances, what's interesting is that the ICC maintains that politics is not part of its mandate and wants to think of itself as some kind of neutral machine that's outside of political time and space. Might this view of international justice threaten rather than advance the goals of democratization? I think that even from an international lawyer's perspective, all treaties need to be interpreted, and there's room in the Vienna Convention to reflect to the object and purpose of the statute, and there are, a certain set of moves that any international lawyer or judge would make in order to think about how to apply a treaty to its, in a particular case. Another example is the example in Latin America of which are a series of confrontations by the Inter-American Court of Human Rights in Latin America with respect to opening up determinations that had been made by various countries after their military rule. And you may have already heard reference to these discussions, and certainly in the work of Lisa LaPlante and others. And so this has become a kind of revival, transitional justice revival. Well, the latest struggle is between Brazil, the democratically elected leader in Brazil and its regime, and the Inter-American Court, where the Inter-American Court is saying that Brazil needs to reopen and overturn its amnesty law. She was herself a guerrilla and a victim of the military torture and detention. And the amnesty law in Brazil has been upheld by its own court. It's part of political transition in that country. And which doesn't mean that it has to stand, but there is a remarkable absence of reflexivity by the regional judiciary about its role, what are its likely effects, what other factors one might think of as relevant to guiding the intervention. I think of the principle of complementarity. It could be a useful guidance. There's clearly no going back to the pre-global time. It'd be nice to put the genie back in the bottle, but there are too many conferences and too many civil society actors and too much interest. So that's not a way forward. But the question today, given these dimensions that have become increasingly disconnected and disembodied approaches to transitional justice, is what ought to guide the relationship of these supranational interventions to local determination. Obviously, one important factor should be the robustness of democracy and the political process below. But we might think of others. And so this is really where my thinking is going. There's definitely a continuum one might think of for a threshold or colorable basis for international intervention. But the question today, often international law and these NGOs see themselves as non-political or kind of some neutral, functioning in a neutral space. We need to problematize and think about these various changes in the field and the various relationships of these actors, and then confront what are going to be clearly competing goals, competing purposes, competing goals, and values. Judicialization can, in many ways, be a salutary development because it's case by case, and it could allow and facilitate the importance of interpretation and bringing to bear the relevant considerations to advance transformation. So let me leave it there for now, and so that we can have a chance for Q&A and discussion. Thanks a lot for your attention.
Down, or would you like to stay at the podium?
I can stand, that's fine,
Okay,
yeah.
that's fine. And Dr. Zeleza, you've been sitting here attentively. Would you like to kick us off with either a question or a comment? And then we'll open it up to the group.
Perhaps I can just make what I thought I heard, three major shifts in the discourse on transitional justice. First of all, the discursive framework itself. I think you're making the point that the approaches have changed from state-centric to focusing a lot more on society and the globalization of that. The second shift, which I thought was fascinating, was the growth in the field itself. From a rather limited, very tentative area of scholarship into now a very major and interdisciplinary area, and of course the contestations that come with that, people feeling that they're losing sort of authority, but at the same time, of course, gaining a lot of insights because of the combination of different approaches. And then the third part, I thought, which was also quite fascinating, was the whole question of the different jurisdictions and the different instruments that are used to, in terms of the governability of transitional justice, from the domestic to the regional to the global systems. And I was particularly fascinated by your examples, two from Africa, the Libyan example, and of course the Kenyan example. I have a very close friend of mine who teaches at Penn State in the law school, and he's been very much involved in the debates with the AU about whether the AU should withdraw en masse because of the Kenyan case. And of course, African civil society organizations are very adamant about the need for proceeding with this particular case. So the contestations between the different levels of governability of jurisdiction and the instruments is a very fascinating thing that I heard from your talk. So
no, that's exactly right. I mean, one could speak hours just about the field itself, right? About how the field has changed and this debate, But I think it's very interesting that in this setting here, that there's been this, this relationship between the lawyers and the alternative dispute folks. That's not always possible. It depends on the institution, depends on the people, and whether they're open to that, because what I'm seeing is that there's this contestation for control, encapsulation, who's going to encapsulate whom, and resources, wanting to go after scarce resources. So it's a very interesting question. And then one would have to turn to field theory and theorization of field to know what goes into calling something a field, right? So, and that, I leave that to other scholars, but I think it's, that too exists here. And you're right, the others are really the discourse and how that's changed, and the relationship of international local. So these are a lot of changes that I'm trying to, sort of summarize by talking about globality. It's kind of a word that's out there, and it can mean so many different things. So I thought it was capacious enough. But we're seeing a lot of struggle, not just within the field, although I'm seeing more developments of these kinds, with connections of people realizing, well, yeah, transitional justice has a legal component, but it definitely also has a lot of synergies with alternative dispute, with mediation, with other. Now there are differences, and I'd be happy to take that up, because once people are in the same room, then you can see both similarities and differences, and I think it's important, to have those conversations. So,
Great. So let's open it up. Other comments, questions?
Can you tell us something about, who are the practitioners in the ICC? Who's defending and who's prosecuting, and is there any discussion between them and the scholars in that field?
Well, there is now more and more. Well, so first of all, who are the practitioners? There is a group of lawyers and judges, many of whom have gone around, have been in prior tribunals, the ICTY, for example, the International Criminal Tribunal for the former Yugoslavia or Rwanda. For young law students and lawyers, this is a fun thing to go and be able to practice international criminal law. There aren't so many settings. You can be a defense attorney in a law firm in a variety of places, and also you can be court-appointed defense. So there are lawyers that have practiced in other tribunals, and there are recent grads. Judges are often seconded from other jurisdictions. So we had, there were American, a leading American lawyer, a woman who. She was in the circuit, now I'm blanking on which circuit, and she was one of the leading judges in the ICTY, I think Gabriel McDonald. So there are, it's a mix. Some of them are trained judges and have been really leaders in their own jurisdictions. Others might be newer at it. But what's interesting is now there's more of a relationship. Scholars are interviewing those practitioners to ask them, what do they think they're doing when they're judging? So there's new work coming out about the impact of the International Criminal Tribunal for Rwanda, on the Rwandan legal system and on Rwanda political. And the political scientists asking questions are really sometimes surprised that the judges have their own goals and the lawyers have their own goals, saying this is not just about Rwanda. This is about vindicating a certain set of international standards and international values. So, one has to have the time. There are a number of young scholars, both in law and political science, that I can think of, who are going to be publishing dissertations. There's a recent article on Rwanda in the Israel Law Review. It's a PhD student from Hebrew U that is publishing on Rwanda, and there are other books that are going to come out in a year on this. So yeah, there's going to be more. We're going to know more about how they think of their own self-reflexivity, if you will. But it wouldn't be surprising, right, that international institutions and international actors have slightly different, identities and a commitment to their own institutions, right? They also think about the relevant conflict in the country, but this wouldn't be, I don't think that would be surprising, but it hasn't been, somehow the fact of that competition and that it wouldn't be a unitary accountability mechanism, right? The relationship of Rwandan judiciary and law, I don't know why we would have thought otherwise, but apparently a lot of the thinking about those tribunals was that it could be now delegated back to the region, that you could just take indictments that were indictments and investigations that occur, started in the international institutions and can go to the local, and that there's somehow going to be a seamless path. And I think the more we know, the better, right? About other actors that are in the global game. So the same is true about interviews in the inter-American system. There are recent work being done by political scientists that are interviewing actors in the Inter-American Court of Human Rights, and the Commission, which has played a very strong role, and seeing what role the commissioners think they are playing in saving the region. So.
No?
Thank you. That was absolutely amazing, the whole talk. But I have a question that goes with Paul's question. You write a book, and there's a new field, then you write a book in 2000, and now we're already at a paradigm shift. But it puts me in mind of...
Stuff is moving quickly,
right,
although it's a long time for me.
If that's okay or not, in that, I sometimes write about IT, information technology, and there I start writing an article, and by the time I finish the article I have to change it because
Sure.
things change so fast. I find that unsettling when we're talking about law. not about politics, but about law. And I wonder, there was the field, and we're already in the meta field. We're already asking about the field before we, I don't know if before, but while we're trying to figure out the field, we're already outside the field. Doesn't that maybe say something about the concept of transitional justice? Maybe we should just stay with international law, or just stay with something else rather than bring. I'm really not being. I'm not challenging. I'm just wondering about the field, if it's so flexible or fluctuating. Maybe we're missing something that we should have held on to before. I don't know what it was.
Well, there are many times I walk into the room thinking, what was, whether it was a mistake. I mean, I did invent the term in '91, and there are several scholars. It was in the grant application to USIP, and then it did take me, many years to write the book, that name, but the term was out there before that, and it was something like transitional justice, a bridge to, that was the original grant application. It's on the USIP website. It doesn't matter. I had a certain idea of what I thought smushing together those two words meant, which was, a contextualizing of justice, that it wasn't ideal. And in every chapter of the book, that was my goal, was to show how the current, problems reflected that tension, right? But now it's being used. So I mean, my conclusion about the way it's grown and is that actually the term seems to have a lot of appeal, right? I can't control the direction of the term, and I don't get $1 every time that it's used, okay? Which is one of the, so I would like to, big mistake, Well, we know that there aren't, you can't patent ideas in that way, but it does seem to have this appeal, this discourse, and it's being used in a variety of different ways. And it's funny because the NGO, the Center for Transitional Justice, that came later, they say, you're the only one who uses it the right way. We know we're using it just in a positivistic way to describe the array of practices, right? Well, I'm like, look, if that's useful to you, it's like you're describing the modalities, fine, the modalities are out there, but we see there are many other modalities, right? I mean, there's you're talking about the most difficult problems of the human condition. So, I don't think one can go back and say, okay, there should just be some small set of narrow questions and we should have stuck to that list. I don't think so. I think what's very interesting, now is the change in conflict, and that we didn't really have a chance to get into why this is happening now, the nature of political conflict, how much of it is civil wars and internecine strife, and that there's just so it's a different set of actors, and it's much more persistent. There's persistent conflict, places like Afghanistan and so on. So there are all kinds of scholars, sociologists that focus on this, political theorists, philosophers, psychologists. I mean, it's, I don't even think I want to put the genie back in the bottle. I mean, it's, I don't know if that, I mean, we could go on, but, in the interest of more, yeah.
Here?
Thank you. That was really magisterial talk. Thank you very much. So, with all the changes in the field and the meta field, and with all the different disagreements, there does seem to be some sort of overarching or underlying, whatever you want to call it, agreement that you do have to come to terms with the past at some level, that there has to be some degree of accountability, and that does seem to be an animating common assumption. And I'm wondering, are you seeing that at all challenged? Because that does seem to be a questionable assumption to me. Sometimes amnesia gets a very, very bad rap, for sure. And most of the time it gets a bad rap for good reasons, right? So, you have paradigmatic examples of Cambodian prime minister at the time wanting to dig a hole and bury the past, and it's usually politicians, for some reason or another, that advocate for amnesia. Often politicians would prefer that what they had done would be forgotten. But there do seem to be some cases where it's appropriate, at least for a period of time, and there do seem to be cases where even the parties involved opt for it. So I was wondering if you're seeing any of that, or
Yeah, well, it's a very interesting and very live question, for example, in Latin America and in Argentina, which is where it all started for me because of being born there and my parents being born there, and then they came from Europe, from Germany, and so, it's kind of like a transitional justice was going to be overdetermined for me, but it raises a question. This was settled, right? And I think the example of Pinochet, of people going to Spain, really raised this for, that first global moment. It's like, wait a second, they decided this, and which is not to say, Pinochet died unrepentant, but he was under house arrest, once he was sent back from England. He died, really in what you might call open-air prison, and at least he didn't die a hero. But they made a determination. And so now I think, there is an interesting question, which is what about this revival, right, that the Inter-American Court is engaged in, and that victims groups have initiated. The steady drum is generally civil society. But what I would end by saying is that this is always political. So the current leader in Argentina, Cristina, there's a politics of these trials. She's giving people something. In a time of scarce, the economy is terrible. Their PR and reputational standing in the investment and the trade area is rotten. But human rights trials, these are human rights trials. She's willing to put the military, of course, it's not her generation, it's the prior generation, it's much easier decades later. So I would say that that's part of it, is that the politics is, often facilitated, having some of these postponed trials. But again, one wonders about whether there can be a general principle, of saying that societies have to. Look at the US. How much did we reckon with slavery and segregation? Yes, we had a bloody civil war because we couldn't resolve it within our constitutional system. Did they ever get, 40 acres and a mule was the proposed remedy? Was there even a truth commission? There have been localized examinations. It went to historians and public debate, but I still think that there are, issues of identity and of politics that reflect the absence of that kind of, so you could say, well, we're a young country, it's taken a certain period of time. The fact that the United States Supreme Court used 50 years as a time period to, think about the, continuing some affirmative action, some factor. I think that's interesting. There's always going to be a question of what does 50 years mean? How many generations? But, when you teach constitutional law and there's no sense of the history, and there's no sense not just of the original history, but of governments reckoning with that, that's what I'm seeing, is that's become the obligation, not the original investigation, because those people may not be, are not alive, and they're, you're talking about some public actors and private actors, but the absence of reflection. So I think that's an interesting thing, is that there's where the duty appears to be, this duty of accountability, and that, I think of the United States, and I think it's a mistake that we haven't really meditated and reckoned with this in a more systematic way.
Yes, Lisa.
I hope you don't put the genie back in the bottle, because then I won't have anything to write about.
And it's not my, I need a vacation, actually, so I'm
so crisis right now about my identity, because I'm kidding about
Okay.
it, but in terms of but the irony is every time I start off a paper and I have to define transitional justice, that's the hardest part of my paper.
No, so just move along.
I do. I actually just put all the definitions. This is how people talk about it. But I think at the same time I live inside of understanding that it's this very new area. Is it a field? What are we doing? And so I see those of us studying and observing it, although in my case I've also done it. I've been an activist, I've been a lawyer, I've also been a scholar. So I feel like there's so much going on in this situation, and one of the, in particular, in trying to figure it out with this bureaucratic model that you have in this formalist model, I guess my question is, who's driving those two models? Because in my mind, what's fascinating about transitional justice is it left room for local determination, often the victims, not just the powerful elite, but suddenly it's created a space where that's possible. And in my experience, what it's been is the local victims have used the formalistic even bureaucratic model for their agenda, and they've turned it into all different things in different places, and that's why it's such a fascinating area of study. But then I see, in some ways, these, I don't know what you would call them, norm entrepreneurs outside trying to impose a recipe book, how it's supposed to be done, which kind of is against the spirit of what it was supposed to be, locally driven. But then I go back to, how do we evaluate it? And that was, that's how I'm constantly trying to figure out, how do we know if this is working or isn't working? Well, we need some goals, we need some aims, political with the capital P. We need to know what we're trying to strive for. And so who decides that?
Well, that's really what I was closing with, which is that if we don't take seriously the fact that there are these different actors, both the local, region, then it's only then that we can acknowledge different interests and different goals and values, and then one can have a more analyzed, view of, well, in this case, the rule of law. In this other case, well, the politics of, is very delicate, and it would be, and there's an ongoing, robust political process where victims have a say. Maybe not the time to have a judicial intervention or innovation. So, I would answer where you ended it, and I think that one can never go wrong by being honest about one's own perspective. What you say, you're approaching it as bing, as a lawyer, as a actor. I think that's always the, to acknowledge that you're situated, and that would be how I would begin and begun, and and then acknowledging the politics that there is, now what global politics means, it can sound like an empty cipher, but what I'm saying is, well, there are these institutions there. Now, sometimes, you say the victims, that it was so salutary, that it was always about the victims. I'm not so sure. If you think about South Africa and the determination made in South Africa, which was, both sides seeing that they had something to gain from the amnesty and from not, pausing there. And there was a political space for that. I wonder whether there's political space for that today, given the normativity of the International Criminal Court. And that's an interesting question. And the victims, many of them were on the opposite side. I mean, if you think about the litigation of Steve Biko and, against the amnesty, and, but victims aren't just one, as not one stripe, and some victims want to talk, others want to be quiet, and some victims want to litigate, and some want to see a trial, and some don't. So again, I think that, it does appear like victims' justice now, in the sense that many of them are, behind some of the litigation, but my attempt is to recontextualize that litigation and not see it as some kind of neutral or obligatory space. All of this needs to be interpreted. International law is not a universal, not an absolute. These are case by case, where there are materials that relate to every case, and there's politics to the revival of transitional justice in many of these places. So, yeah. You had your hand up. Yeah.
We have one more comment.
Okay, I'm just deeply curious. Listening to you, and I'm an historian, so I'm not in your area.
Oh, no, we're all in a field. I said, we're all in a field, honey. That's okay.
I hear you talking about the smushing together of transitional and justice, and immediately when you spoke about contextualizing, I understood that. But where I'm getting confused is to my ears, I may be hearing wrong, it sounds like justice and law, or to be more blunt about it, justice and making somebody suffer for what they did to me is getting used interchangeably. And so I guess I have two questions. One, when you did the smushing, what does justice signify to you, or what were you thinking that word connotates culturally for us? And then two, what made me think about this was when you raised the Civil War, or the war between the states, or the late unpleasantness, however we can, some people still do call it the late unpleasantness in the South, and I have no problem with this. So I wasn't saying that pejoratively. Lincoln's notion of what was just was genuine reconciliation, and none of this talk about accountability or truth commissions or let's see who did what. To him, the just action to take was to repair relations. So against that background, I'm not quite sure what justice means in the smushing.
Oh, fair enough. You know, I see it. I see the illustration you gave. I wasn't quite sure where you were going, but the illustration you gave about Lincoln, I don't see his arguing that that's justice. I see him arguing. I mean, it was, you know, there were people who dwelled on the unlawfulness of secession, right? And so you could say, okay, this is a legal matter, and that the answer to that is union. But to my mind, there was a moment, and there were two possible identities. One was union, and one was equality, and emphasizing what, you know, that other aspect of why the war was fought. And that normative identity was not pursued, okay? Part of the deal, and as you pointed out, there were, you know, amnesties, you know, all of what we know that happened at the end of the Civil War, and is even in our Constitution about that it would be politically resolved. It's a political determination. You know, and the reason that I'm, you know, saying, well, we need more awareness of the various competing goals and purposes is precisely so that we have more pieces and more vocabulary in the toolbox. I wouldn't say that that is justice, okay? I think of it as one political identity that was pursued at the end of the war, and it's the one that won out. And I have to say that every time we have a political conflict that involves those states, and, you know, my view is like, well, you know, maybe it was the wrong decision. Maybe, you know, should have let them go. I mean, there are certain ongoing secession questions that, you know, but we need to preserve, we need to have a richer vocabulary, not a narrower vocabulary. Now, when you say, what did I mean by transitional justice?
The word justice.
Yeah, the word justice was.
What does that mean to you?
Okay, well, it's not just it's not, first of all, what I wrote about was that it was contextual, and that it would be provisional and, you know, and limited, and that was one of the characteristics, and unstable, that would be determined by the society. But I have a whole chapter on historical justice, on what is justice from a historical perspective, where you see that people slog out these various identities and these various, you know, historical questions. So it's not by any means just legal, okay? The word justice is a very capacious term. You know, I heard references to Aristotle earlier, and, you know, other political philosophers. It's not for me to define the origins of that term, but the point was adding transitional as a modifier of justice, which was that this would be something that would be open to change, that it was unstable, and that it referred to a backward-looking set of context and a forward-looking one, and that all of these instances that we're talking about include that. And I think of Lincoln's choice, and the choice of those who succeeded, you know, as reflecting that it was, you know, for the immediate forward-looking, you know, well of the Union, they put aside, set aside, and, you know, maybe they thought that it could be re-raised at another time. But, you know, insofar as we see, you know, whenever we see, you know, contestation of the federal government and of that idea, I think back to that period and the kind of thinness of only having an identity of union, right?
Just to press it a little then, from what I'm hearing, you said that it's not just tied for you to law.
Oh, not at all. My book at that time goes into, you know, really a lot of different modalities I take up. Yeah.
But is it tied to doing what's right? Or is it tied to responding to somebody else did something wrong?
It's not seen as just somebody doing something wrong, I assure you. No, it's 300 pages, and that would really not, you know. Yeah, no, that's just one chapter, and in fact, if anything, as I said in the beginning of my remarks, I was very uncomfortable with this kind of reductive questioning about punishment versus impunity, as if that was the relevant question. So I think we would agree. I take it as a, you know, a comment that that's not the, you know, the relevant question. Yeah.
Okay.
Well, I think we're going to call it for now for another break, and more questions that arise after our last panel. So
Thank you.
We will be back in a little less than 15 minutes to begin our last panel. So let's say 2:17.
or something.
But thank you very much. Thank you.